Good morning, everybody. Thanks so much for joining us both on Zoom and here at the Friendly House. We have a pretty full house today, I guess I should say, or crowd. So thanks so much for everybody for joining us. Thank you for the AV team for setting all this up. Thank you for the coffee and all the goodies for everyone who brought that. We really appreciate that. Just to be very clear, the Humanist of Greater Portland strongly believes in the freedom of speech, but the views expressed by myself, our reader, today's speaker, and HGBP members and our guests at today's meeting are not the official views of the Humanists of Greater Portland. So just want to make sure that's really clear. And then also kind of wanted to just give you guys a quick little definition of humanism so that you have an understanding of who we are and what our community is about. So humanism is a way of life that guides us to lead ethical lives and to do good without relying on the supernatural. It is a rational philosophy that encourages the use of science, reason, and free inquiry. Humanism promotes principles of social compassion to enhance the quality of life and to contribute to the well-being of society. So that's what we're all here for. And I'm really excited today. Our reader today is John Daggett.
The book Irreducible, this is a excerpt from the book Irreducible by the physicist and pioneer in computer technology, Federico Fagan. And it's also a bit of the reading will come from an interview of him in 2024. A little background. In 1990, at the peak of what our culture would call a success, Federico realized he had lost connection with his emotions and inner reality. He was suffering, and rather than turn away, he decided to go toward that suffering and learn something. His struggles peaked one night with a powerful surge of energy emerging from his chest. This alive energy was pure love. And surprisingly, the source was him. Over time, he found that this experience was another dimension of reality. It was much like near-death experiences and trauma-induced out-of-body experiences that hundreds of thousands of people across the world have experienced. So now to his actual words. We are repeatedly told that we are biological robots, while the intense personal investigation that occurred after my awakening revealed otherwise. Rather than a body, we are spiritual beings temporarily imprisoned in a physical structure similar to a highly sophisticated drone. If we allow ourselves to be convinced we are only our mortal body, we will end up thinking that everything that exists originates only in the physical world, and we will not even ask ourselves about the nature and purpose of our creative impulses and our emotions. I have to wait a second. My breath is short. I've got PVCs going on here. We will also avoid the meaning of life, which now I understand is the most important part of the human experience. If we believe that inanimate matter can explain all of reality, we will support an assumption already falsified by the fact that we are conscious. Aristotle said, "To educate the mind without the heart means not educating at all." We cannot let physicalism and reductionism define human nature and leave consciousness out of the description of the universe. If we take our inner world seriously and begin to investigate it with love and determination, we will discover a new worldview that promises a creative and cooperative future for mankind. Let me take a break here for a second. Quantum physics is already telling us that the universe is holistic and creative, and new developments in quantum information theory justify a new and revolutionary theory of consciousness and free will. We think we live in a world where we are objects, separate entities, which interact with each other in time and space. That has been the traditional worldview of science. Nowadays, we have to think of objects as states of fields. They interact with each other, but at the same time, they are not separate from the field. I am proposing these quantum fields are consciousness. We think that when a person dies, it is the end of our consciousness because we've been told that consciousness is produced in the brain. It is the other way around. It is the brain that is produced by consciousness. So consciousness uses the body as a tool to know itself. Clearly, our body is temporary, but we are not temporary because we exist outside space-time. We want to know ourselves. When our body dies, we don't go anywhere because, in a way, we were never here.
All right, I'm going to go ahead and introduce our speaker for today. Hopefully, I'll say your name correctly, but if I don't, I've already got pre-approved forgiveness. So, Amitai Heller is a legal director of the American Humanist Association. Mr. Heller earned his law degree from the City University of New York School of Law. Before joining the American Humanist Association, Mr. Heller won several high-profile cases securing end-of-life choice for terminally ill patients and civil rights for people dealing with disabilities. So I'm really excited to hear what he's going to talk about today. So thank you so much for joining us, Mr. Heller.
What I'm going to talk to you all about is the AHA, American Humanist Association, what we're doing with our legal work, kind of what you can expect from us, what's going on with us, and then kind of share a little bit about how we're viewing the present moment, or how I'm viewing the present moment as the legal director, as your legal director, in a sense, you know, because y'all are a chapter. And then we'll take some time to go over questions that you all have. And I think that's the presentation for today. So that's what you can expect. But before we get started, let me tell you a little bit about myself. And the intro was great. And I'm going to share a little bit more about where I am, and kind of, I think my background might help you understand how I understand the law, and what my background is as a litigator. So, you know, I was just kind of doing my thing for my 20s, like working in the service industry, playing music with my friends, doing stuff like that. And I was living in San Francisco, and I just kept getting evicted from my house over and over again. Evicted because I mean, it wasn't things that I was doing. It was people kept buying the houses I was living in San Francisco, and kept displacing me, and I had to go find new places, different rent control units. And finally, I went up to the San Francisco Tenants Union. I said, you know, what can I do about this? Can anyone help me? And they said, well, our model is that you have to come and help yourself. So I joined them, got some legal advice from them, and then I became a volunteer with them and got really involved in organizing, doing movement work. This was around the time of Occupy, and it was like there was a lot in the air. It was a really exciting time, and it kind of taught me about the power of organizing, the power of movement work. And from that, I also got into labor organizing. I worked with some unions all before law school. Then I went to law school, and my plan was just to become a tenant attorney. You know, just kind of that was what I knew. But it was such a stimulating place for me that I just got into all of it: constitutional law, the church-state separation, everything about it. And I said, you know, I'm just going to do what I think is most impactful in the current moment. After law school, I moved to Louisiana and did poverty law on behalf of people with disabilities in the state. And it was kind of all over Louisiana. If anyone's been there, there's a lot of work that needs to be done. I worked in a lot of institutional settings, got people out of state psychiatric institutions, worked on a lot of Medicaid access, things like that. We formed the first legal services union in the state at the time that I was working there. And then I went over and worked, when I moved to Portland, Oregon during the pandemic, I started working at Compassionate Choices. If you all know that organization, it's an I mean, you're here, you probably know about Compassionate Choices to a certain extent, but it's a end-of-life autonomy group, nonprofit that promotes access to end-of-life care, death with dignity, medical aid in dying, stuff like that. Litigated cases around end-of-life care all over the country. And then I saw that there was an opening at the American Humanist Association to work on church-state separation issues and rights of humanists around the country. And I jumped at the opportunity because
like we see what's happening in the country right now, and we see the rise of Christian nationalism. And I really think it's one of the defining challenges from a legal perspective of our time. And I wanted to be in the muck, kind of working on the stuff that I think is kind of like the threshold that's keeping a lot of stuff from, collapsing. Because once you don't have church-state separation, then a lot of other stuff happens. So that's kind of my background. But what I really believe and what I'm going to talk a little bit about is that we're kind of in a moment where just going to court isn't enough. We really need to build up our movement as humanists or as secular people more broadly, or even working with religious folks to kind of find a way to grow our power and grow our base. And there's ways to do that through lawsuits. And then there's ways to do that through organizing and activism, and trying to think about how we can make those two worlds meld together, I think is like the necessary conditions for victory right now because of what we're going to talk about. Okay, so before we kind of go into gloom and doom of the current moment, I want to say that there is some stuff that's happening that's good in our world. Like there are still winnable lawsuits. We've had some good cases recently. The American Humanist Association, along with the ACLU of West Virginia, recently sued the West Virginia Water Development Authority and had what I would call a successful outcome. We'll talk a little bit more about that, but the West Virginia Water Development Authority dedicated $5 million of redevelopment money to a Catholic vocational school to do Catholic wastewater training, Catholic plumbing, Catholic, they are indeed a vocational school, and they are graduating people to work in the fields that are necessary for the state, we think. But in order to, as part of the allocation of the $5 million, some of that money went towards Catholic advocacy work, which was actually anti-abortion work, anti-reproductive rights, and then other parts of it went towards Catholic education. So we sued, and we said that it violated West Virginia's version of the Establishment Clause. I'll try to be less legalese to the extent I can. The Establishment Clause, and we'll talk more about that in a second. The Establishment Clause is the thing that says we don't establish, a church in our country. That it's the separation aspect of the church-state separation. The clause that says we don't establish churches with our public money. And so what the court found in that case was that part of the funding was unconstitutional, the part that went to the advocacy and the education, but they allowed them to build some buildings for the university to assist in their construction costs. The logic of why some things are permitted and why others are not permitted, it's a bit challenging to explain these days. I'll say this, and I keep saying we're going to talk about it later, but what I mean to say is maybe 15, 20 years ago, we think pretty clear case that the whole thing would have been tossed out. But now, given the new legal landscape, it's not quite so simple. And so in addition, the Catholic school also agreed to not require a degree in Catholic studies to participate in the program. We'll see what that actually means in the future as we monitor it. Is that just in name only, or can non-Catholics attend without kind of getting proselytized towards? That is to be determined. But so in the current landscape, this is considered a victory now, right? We got a lot of the money clawed back for the things that we felt were blatantly unconstitutional, but they still got to spend some money. Another case that we just resolved was against the city of Ocala, Florida. In Ocala, which is a small-ish town in Florida, they held, this is going back in 2014, so this is kind of explaining how long it takes to work through a lawsuit sometimes. They held a public prayer vigil where the sheriff, the mayor, the police department decided that they were going to, there was a lot of gun violence in the community, and they decided that they wanted to do a public Christian prayer vigil. Notices to people all over Facebook, and they said, you know, your attendance is required. Come on out to pray with us, to pray the violence away. We sued over that. There were some people, some of our members were in the audience at the prayer vigil, felt offended by all the Jesus talk, and we won the case, but let's talk about how we won the case. Back in 2014, we had a trial, a district court level, it was in federal court. The judge said, yeah, this is a clear church-state violation, church-state separation violation. And then there was an appeal. We were successful at the appeal. And then at the US Supreme Court level, they changed the legal standard for the Establishment Clause. So there was a time that you all are familiar with where there was a test. And this, I'm getting into the weeds of the law here, but we used to have a test called the Lemon test. That changed after, and now instead of looking, now what courts are being told to look at to see if something violates the Establishment Clause is the history and tradition of our country. So it's not a great standard for our side, but there are still ways that we can win, and we have great historians working with us to try to establish that, you know, actually, you know, this country is and was rooted in church-state separation, in, you know, religious freedom for all, including to not be religious. And so we went and had to do the whole thing over again with this new legal standard. We won under that standard. And then at the appellate level, at the next level, we decided that we were just going to settle the case instead of keep fighting it out. And so that case is good precedent and it's on the books. You know, part of our rationale for settling at that juncture was we didn't know what would happen if the appellate courts took a look at our victory, right? We don't want them to undo this good law that we have on church-state separation in Florida. Everything's kind of up for grabs right now when it comes to this stuff at the US Supreme Court level. And anytime a case like this gets up in front of the US Supreme Court level, federal US Supreme Court level, it creates kind of new risks for our movement. And so keeping things out of the highest court is part of the game right now. And until we have to, right? We're not going to just concede everything, but we're approaching things tactically from a harm reduction perspective, I would say, with our litigation. Okay, so what I want to say about these cases is we definitely won them, but we won them in a way that is suggests that things aren't quite where they should be. These cases that we're winning, we're kind of winning a little bit more by the skin of our teeth than we would have been 20 years ago, I think, if you look at the reality. And then there are certain cases that we're just not bringing anymore, even when the law supports us, because we're worried about what it's going to do more broadly to other people in others in similar situations. And we don't want bad precedent to go up to the US Supreme Court. So how did it get this way? And we'll start with how did it get this way, then we'll get into what we're going to do about it. So here in this hastily put together metaphor, I have two fish, the Establishment Clause and the Free Exercise Clause. They're of equal size. They are trying to eat each other, but they are somewhat in balance. The Free Exercise Clause is the part of the US Constitution that says everyone in America has the right to exercise their religion freely. And then the Establishment Clause is the part of the Constitution that says, yeah, but the government doesn't get to choose sides. The government doesn't get to establish a religion. And that means doesn't get to choose between religious denominations, but also between religious and non-religious people. So, during the kind of halcyon days of civil rights law, 1960s through the 2000s, they were somewhat in did I use that word correctly? Halcyon days? Yeah. That's the first time I've said that out loud. They were kind of in balance. And now we kind of are in this new era where the Free Exercise Clause, the Religious Freedom Restoration Act are kind of chomping down on the Establishment Clause, and we're out of balance. And what that means is there's always kind of been this innate tension between the Free Exercise Clause and the Establishment Clause, right? But that's reflected in the jurisprudence. But what we're seeing now is similar to the case that we were litigating in West Virginia, is that we're seeing a reversal of the concept of religious discrimination. So it used to be that the court said, we don't allow taxpayer money to go to churches, right? That's just kind of the big thing. Now, what they say is it's discriminatory for taxpayer money to not go to churches because that's discriminating against religion. So anytime that you offer a public benefit, say to a nonprofit, that benefit, like a contract or something, that benefit now needs to also be provided to religious groups. So when we were looking at our case in West Virginia, what the court said is, you put out a public bid for, you ask people to come in and do this vocational service. If we're not, vocational training for these wastewater treatment, if we're not going to allow religious people to apply and get this, aren't we discriminating against them? So that's kind of like the reversal of discrimination concepts that we're now in, and that's the paradigm, right? So that's a total reconfiguration of like the way that this concept has been understood for most of our lives here. So, and then in addition, we have the Religious Freedom Restoration Act, which was actually a law that the AHA, when it was starting to get passed, supported. What it said is it was intended to fix certain conditions for some minority religious groups. For example, to let Native American people use peyote or things like that, to get some exceptions for religious practices for groups. And now that's kind of been weaponized by the Christian nationalists to misgender people, to discriminate against LGBTQ folks, all in the name of religion. So this is kind of where we are thematically. And here's some more specifics. We talked about religious discrimination as an accommodation. We saw this last year. There was a case called Mahmoud v. Taylor. Were any of you following that? Okay, so there's a school district in Maryland where they were not allowing religious children to opt out of LGBTQ materials in the public school system. Part of the education for elementary school students was they read books that acknowledged the existence of gay people, not promoting a particular anything, just saying, here's Uncle Bobby's wedding. It's with another man. And the school system said, if we start allowing people to opt out of just being exposed to things, not proselytizing, but just being exposed to other concepts that are necessary to live in a society and to create a tolerant world, first off, the administrative burden on us is going to be so great that people around the country are just not going to teach these, I'm putting quotes in case anyone's not watching me, divisive concepts. And the Supreme Court ruled in favor of these religious students. So now anywhere in America, you have the religious right to opt out of anything from a public, that's part of a public school curriculum because it violates your religious beliefs, kind of regardless of the administrative burden on the school system. So that is bad, very bad. Yeah, okay. And that is the state of the law right now. And the parameters of what exactly that means and when that's going to be litigated over the next decade or so, but that is the current state of the law. We're seeing an increase of religious influence in public schools. There's a bunch of laws in the South, in Texas, in Louisiana, I believe in Arkansas as well. Yes, in Arkansas, where they're trying to mandate the 10 Commandments to be in every public school classroom. There was some initial signs that the courts were going to hold the line on that. There's very clear case law from the 80s saying you can't. It is religious to put the 10 Commandments in school. I mean, that doesn't seem like a particularly controversial statement to make, but you know, the kind of framing that the Christian nationalists are using as cover is that this is part of our heritage, our Judeo-Christian heritage. It's part of how we got, you have to understand how we got to where we are, and we're a Christian nation and blah, blah, blah. So that's the argument. And we thought they would hold the line, but there are some signs that the Fifth Circuit Court of Appeals in Louisiana is by far the most conservative court in the whole country. It's the appellate court there. And they had said, no, initially they had said, no, it still violates the Establishment Clause to require children to look at the 10 Commandments. You know, it's clearly a religious message, and that's clearly shouldn't be there. And now the Fifth Circuit has decided to rehear the case en banc, which means in front of a larger group of judges, which suggests that there's an appetite to allow the 10 Commandments to be in schools. But we will see. The Americans United for Separation of Church and State are actively litigating that case, and they're fantastic attorneys. So if there's a way to win, they will win. But we can expect that to go up to the U.S. Supreme Court as well. So that's on the agenda. Can we have 10 Commandments? And then I think even scarier was this case called St. Isidore versus Drummond, where this was last year, where a charter school in Oklahoma, remember we talked about how it's discriminatory not to allow religious people to receive government contracts. They took that logic and they said, well, this also applies to charter schools. And actually the state of Oklahoma, of all states, said, actually, no, you know, we don't want publicly funded Christian charter schools. That's a public school. We have church-state separation. And they went up to the U.S. Supreme Court. And because Amy Coney Barrett, the judge from Notre Dame Law, was conflicted, she didn't sit and listen to it. And so the case was split 4-4. And so now for another year, we don't have public religious schools in the country. But that is on the docket, and that will be relitigated most likely in the next 5 years or so. They're currently finding ways to work that up through the court to challenge the existence of secular public schools in America. So one more thing to talk about. There's a lot to talk about, but another thing to talk about, to worry you all about, to keep you up at night, is the rise of ministerial exceptions, the church autonomy doctrine. You know, part of what I'm talking about here is that the church gets exempted from a lot of laws under the idea that churches, religious institutions, under the idea that it's not the place for the government to interfere with religious groups, right? So they get to do their own governance. If we required them to hire, say, gay people, that might violate their religion, and therefore they get to be exempted from that. But it's also been applied to a lot of other stuff on top of that, like, Fair Labor Standards Act, minimum wage laws. They're kind of being exempted from all law right now, so they to do as they wish. And we're seeing that kind of increased into almost every arena. Very, very little is safe to allow us to enforce laws against religious groups right now in America. They're kind of isolated and operate within their own legal regime. Okay. So how did we get here? I think you all have been watching this pretty closely, and you all could come up with your own legal theories, your own theories about why the legal world is what it is. But I'm going to talk about a couple of things. The US Supreme Court is just really, really, really bad right now. It is not our friend, and it is being run by people with a agenda, and their agenda is explicitly to make America more religious. And it is being propped up by the Christian nationalist legal infrastructure, who are very wealthy and powerful. You have groups like the Federalist Society, the Becket Fund, Alliance Defending Freedom, and they all want the same thing, which is maximum freedom for religious groups at the expense of the rest of us. And then I think what we have to understand is they've been at this for a really, really long time. This is not new. They just kind of broke through recently. But I wrote Principled, Relentless, Experimental Christian Nationalist Litigation, right? They have just been at this. They've been getting laughed at courts for 40 years, and then until things changed, right? They just have been putting forward these, what we would have 20 years ago called wingnut legal theories, are now the theories that have been adopted by the US Supreme Court. So they're not afraid to fail. They were never afraid to be laughed at, and they just kept at it. So let me get a time check. 10:38. Okay, I see it. Okay. I think I could. So let's talk about, so why should we bother? Right? Things are really bad. Why should we bother filing lawsuits? I hear from a lot of people, if the courts are so bad, well, shouldn't we stop? Right? Shouldn't we just do damage control and work on, I don't know, get with our lawmakers, work on electoral stuff? There's a lot of different routes to winning things. Very valid question, I think. And I think one that everyone who's litigating these cases needs to be asking themselves. Okay, so I think it's important to understand that we can still win because a lot of these courts still support us. I think most judges are still on our side. And if we can keep things out of the US Supreme Court, we're in a much better place. This is a list of all the statistics of who the federal judges are in America. And you will see that it's pretty balanced, actually, in terms of who appointed the federal judges right now. So, and then a lot of the, Reagan appointees, the Bush appointees, they still support church-state separation, right? It's really this kind of new magnified judiciary that is kind of taking us off the deep end into a new realm. And then on top of this, every state has its own constitution, and those states have protection for church-state separation as well. And we can litigate cases under state constitutions. So when we went to West Virginia, we didn't bother making federal claims like we would have done 20 years ago. What we did was we just said, actually the West Virginia State Supreme Court state constitution says this, not the federal constitution. So it is quite a day where the state Supreme Court of West Virginia is more liberal than than the US Supreme Court, but that is where we're at right now. Okay. And then you get some surprises and when you litigate in state Supreme Courts. This is an example. Montana just was the first court to uphold gender affirming care for minors, to say that it violated their state Supreme Court's constitution. There are other red states that have pretty good state Supreme Courts, or we can still have victories. So we're looking at those states to litigate these kind of novel claims to fight back against these issues that we care about so much. And then why else should we file courts? Because if we don't, they're just going to eat us up. We have to defend, we have to hold ground for our people all over the country. There is still a lot to defend. We built up the wall of church-state separation over decades, and it's going to take them decades to try to knock it down. And we need to obstruct them at every single step and make sure it's hard for them. So we're going to keep doing that. And then the other thing that I want to talk about, and this is kind of what I think it all kind of comes down to, is that even when we lose, we can do it in a way where we're building power. This is this picture here is from Bowers v. Hardwick. This is a case, the very first case that went up to the US Supreme Court to challenge anti-sodomy laws in Georgia, where the US Supreme Court in the 80s said it is constitutional to ban sodomy. And then in the 80s, that created this massive movement of people who fought on those terms and kept pushing and kept relitigating the issue. And with each loss, they kept growing stronger and stronger, and they didn't give up. They used it to mobilize their movement. And then, now gay marriage is a constitutional right. Okay, so it took them 40 years to get there, 35 years to get there, but we have to understand where we are right now in the process from a legal perspective in the struggle, and we're closer to here of needing to build our momentum even when we lose, and even sometimes through losing, to get attention to these matters and try to use that to buoy us towards a larger movement where people understand the terms and the stakes of what's going on. And you see after Bowers' loss, you can read from the literature, it's actually very good for the gay rights movement on the ground, right? They used it as a way to kind of grow. And that's where we are, and that's where we need to be. So here's our strategy. Here's what the AHA is going to do for the next few years. Okay. We're going to try to grow our movement by litigating with other civil rights groups, not just church-state separation groups, right? But also partners inside and outside of the secular legal world. So we're going to try to find ways where I'm actively partnering with other groups. We're going to work not just with like the ACLUs, the Southern Poverty Law Centers of the world, but we're also going to work with reproductive justice advocates, with transgender rights advocates, with all sorts of folks who are aligned with us, because we need to grow our base and grow our power. And we need to show people where humanism fits into their world. We need to explain how when you can't go to a secular hospital, you can't get an abortion, right? And we have to be making these connections extremely clear to people about why it's important for them to live in a world where you can have separation of church and state and how it impacts them directly. And we can do that through our litigation. In addition, we're going to be defending the rights of humanists to be free from discrimination. There are still very good laws on the books, and they still say, you can't be fired for being an atheist. You can't be forced to pray at work. You have to be able to, if you're being institutionalized, you can't be institutionalized in a Christian facility against your will. If there's all these ways at schools, kind of like the biggest domain right now, we're going to be fighting to make sure that people are not having their rights taken away from them. And then we're going to keep bringing innovative cases to grow our movement and attract new people and explain why humanism is relevant. So talking about understanding what it is that the Christian nationalists did to win, they kind of, they brought these cases that went all the way up to the US Supreme Court that explained, what is it that they want to do with charter schools, right? They want to make charter schools Christian, but that also benefits the charter school movement, right? That means that there's more charter schools. That more charter schools means less teachers unions, right? They are making these connections with these groups and explaining to them why that they should join on with them. We're going to do the same, and we're going to be doing it through lawsuits that point to these connections. So that's kind of the plan. We are currently in the process of building these cases. We're actively litigating some that are confidential right now that hopefully in the next few months we'll be able to talk about it. Maybe I'll come back and share some more about that when they become public. But that's kind of what we're doing. I think we need to be thinking of this kind of from a movement perspective, less than just like a lawyering perspective. And lawyering is just a part of the movement. I think my sense of church-state separation litigation is that because the law had favored us for a very long time and what we believe, it was enough to kind of go in and just say, well, that's what the law says, and you just can't do that. But that's not what the law says anymore. And so now we need to find ways to change what the law says. That is really the mission for us. So some concluding thoughts. I think it's important to understand humanism as more than a metaphysical position. We believe as humanists in more than church-state separation. And when we articulate that, we get into rooms, right? When I'm talking to reproductive rights people, they say, why are you having this conversation? And I get to say, well, humanists have believed in the right to abortion for far longer than any other group you can identify. Why do we care about transgender rights? Why do we care about workers' rights? These are humanist positions. And when we can articulate them to other people through kind of our humanist manifesto, the 10 Commandments, whatever it is that you want to point to, I think it opens people up to our group and allows us to build our base and to draw more people into our movement. I think we need to be pretty candid about where we are and the current state of affairs. We need to acknowledge that the law is not on our side right now and have some tolerance for defeat and understand that there's a bigger strategy at play and that we can lose in good ways. And that sometimes it's just important to bring that out to people and to make sure people understand the state of affairs, and that you do that only when you're honest with yourself and with others about where the law stands right now. And then we have to learn from our opponent's success. What did the Christian nationalists do to end up in this position? And it wasn't just money. It was a lot of money. They had a lot of money, but it wasn't just money. They are relentless. They are principled. They just kept pushing until they got what they wanted. And what's that? Principled. They have principles. They believe in something. They absolutely do. They believe that in a Christian America, and they are willing to do what it takes to get there. And we need to be firm with our principles as well. So that's kind of the end of the presentation. I actually think things are kind of bleak right now, but I actually think we're going to win. I do really think that we're going to win, because when you talk to people and when you look at not just statistics. People, like religious people, want church-state separation as well. They really do. This is a really fringe position that has kind of taken over our countries. And once we articulate to folks why, even as religious people, this doesn't benefit them, and once we articulate our position in ways that's attractive to them, that's true to us, I do think we're going to win. We just have to be ready for 20 years or so of struggle, and that's just where we are. So legally, not necessarily socially, until this U.S. Supreme Court flips, we are up against it, and we're just in it for like the long haul, and we need to kind of bear down and get tough and fight like hell, and that's really the only way we're going to win. So that's where we are, and that's the presentation for today. So I have time for plenty of questions.
All right, you guys. All right, so we'll go ahead and start with number one.
You see a split in the Christian world, because I have a lot of progressive Christian friends. And can we get support there?
Absolutely. There's
a massive split in the Christian world, and there's so many Christians who are on our side. There really are, and we are working on allying with them. We just filed an amicus brief with a group called the Interfaith Alliance. The AHA is very invested in building up our partnerships with faith groups. Absolutely, and that is absolutely part of the legal strategy moving forward as well.
Number two.
Yes.
Sorry.
We recently had this, I guess it was National Security Policy Review or something that Trump put out, that he said that it's an established fact that non-Christians are likely to become terrorists and all of that stuff. And it's an absolute lie. Why aren't we publicizing the fact about how few humanists there are in prison, how few humanists have ever been convicted of anything, about what really good people we are? I mean, it's a blatant lie, and it ought to be called out for sakes.
Yeah, I'm
With you on that.
Why not?
well, I know that
AHA has made statements about that executive order. I don't know. You know, part of my job is to bring lawsuits, frankly. I could tell you why that specifically is not a good lawsuit to bring right now in this present moment, but I agree with you in principle that it's correct to point out the hypocrisy of that. You know, there is a certain extent where, due to the like relentless onslaught of all this stuff coming at us at all time from the executive, you know, sometimes it just kind of goes away, actually. And they don't, like, when you fan the flames, sometimes it just makes things worse. Whether this executive order is like pretty toothless. It's kind of just a policy statement. And that is offensive, but from a lawyer's perspective, it means we don't sue over it. But you know, I can bring it up with the policy folks. I can talk to people at the AHA about it. If you want to see more action on that, I'm happy to pass that on.
Question three.
I grew up in New York State and went to school, parochial school in the 50s, K through 8, or 1 through 8. But New York supported Catholic schools. I remember when the textbook money came in from New York State, and the books were a lot better after that. Why would that be legal back then, that New York could support Catholic schools?
I don't know.
I got one question.
I don't know.
Yeah.
Think so.
Say that things got better in the 60s around church-state separation, so it's possible that has something to do with it. But I don't, without knowing specifically more about the textbooks and the funding system.
Yeah. How did that happen? That's a good question. I don't know.
I just did.
Yeah. But the thing I think, and I guess this kind of
Speaks to a larger issue is that as lawyers, as litigators, we are only able to do stuff that people tell us about. So part of what I'm trying to do at the AHA is like reach more people, make sure that people have our number. And that's something that you all can help with. Make sure that people know we're out here and that we're litigators and that we will defend their rights. So if you know people in other states, it's not really that much of a problem, this stuff in Portland per se, and we're lucky about that. Although there is a significant rise in Christian healthcare in Oregon, which, I know from my work at Compassion and Choices, it's getting increasingly more hard to access medical aid in dying because of the prevalence of Christian healthcare outside of Portland. In Portland, it's because of OHSU, where they're going to have practitioners there, but it's actually kind of hard out in Eastern Oregon right now to find people to provide, or Southern Oregon to provide people who will provide that care. So.
All right, I'm going to go ahead and ask a question from the chat. This is from Kurt Mackey. You say the law has changed, but the Establishment Clause is still part of the Constitution, and it hasn't changed. So how does that work?
Well, the interpretation of the Establishment Clause has absolutely changed, and the tests that we use to determine when something is an Establishment Clause violation has changed. So you have the plain letter of the Constitution, and then you have how judges interpret the Constitution. And those are two very different things. The current US Supreme Court definitely interprets the Establishment Clause right now to be, it violates the Establishment Clause if it violated the Establishment Clause at the time of our founding. So that's a change. It really is a change. And I don't know what else to say about that other than that it is a change and that it is real and it prevents us from litigating cases under that theory. So we're not just going to file cases on principle knowing that we're going to lose and that our rights are going to be clawed away necessarily. We're going to try to find new approaches and new angles to attack from.
Great. Question 4.
I agree with what you guys are doing, absolutely. But you have a very relatively low profile in doing these kind of things because I back American United with the separation of church and state, and I know what they're doing. And they're active at recruiting, and I get a magazine and I get email from them every week, I think. How long has AHA been working on this subject?
So AU,
and they are great. They're great. They're fantastic. I think they have a lot of attorneys working with them. Right now, I'm the attorney at the AHA working on litigation. So if you consider the scale of things, I think we do punch above our weight in terms of what we're doing. But we're not AU or Freedom from Religion Foundation. They also have over 10 attorneys. I believe the AHA legal department started in 2014. There's actually they did a really good job, actually. They have a lot of cases under their belt and a lot of pretty big wins. There's some US Supreme Court cases. They've done a really good job. And then I came after about, I believe it was 2 years without a legal director. So I'm kind of coming back in. I came in, I want to say 8 months ago, and I'm kind of just restarting the program. So I'm in the process of building up all these cases, and of which you'll hear more about, hopefully, soon. Yeah.
Question 5.
Help me understand more the position of the courts at the high level with regard to the government funding religious organizations to do social services. So it seems to me that one reason you might want to do that is because churches tend to have a lot of resources and they have more infrastructure maybe than other groups. And so you have like for helping refugees, you have Catholic Charities and ecumenical ministries of Oregon and that sort of thing. They have kind of the organizational infrastructure. But it seems like you could have a contract saying these groups are not allowed to proselytize and put their religion, kind of push their religion on the people they serve.
Yeah, and I think
that's what's changing. So that's kind of, there's still kind of an open question of law as to how religiously neutral you can make a religious group in terms of their proselytizing via contract, and at which point it goes over into, well, you're just discriminating against my religion, and my religion, part of my religion is to evangelize, is to proselytize. And so when you're saying I can't do this, you're actually discriminating against me on the basis of my religion. That is the argument that these groups make. And so should religious groups be able to do charity, and should they be able to get money to do charity from the states? Like, that's pretty harmless. I mean, we're in some sense, like, we're glad that the Catholics are standing up for immigrants right now. Like, that is a very good thing. The question is, what does that come with? And are we giving money to people who refuse to abide by anti-discrimination law on the basis of their religion? And we need to decide. I mean, it kind of doesn't matter what we think at this very moment, but as like long term, we need to think about what we want and how we want that relationship to sit, I think. I mean, it does matter what we think right now, but I mean, in the U.S. Supreme Court doesn't care what the humanists of Greater Portland think about that.
All right, question 6.
Yeah, do you think that the conservative members of the Supreme Court are intellectually honest in their textualism? And if so, is there ways that we can use that in our favor?
I think I would have to
justice by justice to explain to you how I think about each one of them. I think that there are some who are intellectually honest in their textualism, and then I think there are others who are purely driven by religious fervor and spite. And without going into any names, well, you know, there's always the chance that we're up there at the U.S. Supreme Court, but I think yeah, we make those arguments when we argue there. Do we think so? Yeah, we kind of have to. Lawyers kind of exist in this fiction where you just make the best arguments you can and hope that people act intellectually honest, because that's kind of like the name of the game, I think. But yes,
Historians to
yes.
make the case in the textualist context.
That's right. So we have our
they have their historians too, and our historians are better than their historians, I would say. But you know, there's something when you I don't know, you all, I'm not a psychologist, but you all can weigh in on, for whatever reason you think this is true. Maybe you're preconditioned to agree with a certain set of facts because of your religion, even if it's not, doesn't meet the highest academic standard. But I do think, you know, like the case we were talking about in Florida that we were litigating, we were talking about how it was never part of the nation's tradition and history to do public prayer with the mayor and the police, right? We cited the history that supported that. They cited the history that supported their position, saying that it was. and we won. But that is as much to do with the objective status of the historical record as it is about the predilections of the judge that we got in front of, to be quite frank. So, you know, it's hard to say. Does that answer your question? Yeah. Yeah. It's yeah.
We have another question from Zoom. This is from Jules. What is the official position of the Christian Nationalists on climate change?
I don't know if there's an official position. They're certainly skeptical of it. I assume it's if it's aligned with how they do politics, they mostly don't believe it in, and then there's some who do. I don't know that there's an official. They don't have like a body. They're like a collection of,
yeah,
you know, they're smushed together with a bunch of different churches and different like libertarian groups and anti-environmentalist groups. And I mean, the Christian Nationalists don't believe in evolution. And if you don't, so they don't really believe in science. So they probably don't believe in climate change if it's not convenient for them, but maybe some of them do. I don't know.
All right, question 7.
Are we in touch with Freedom from Religion Foundation? Are they on board with you with the idea that we shouldn't be pushing to the Supreme Court, to the federal Supreme Court?
I talk to them regularly. I think, you know, and let me just say this. It's not that we shouldn't be pushing to the US Supreme Court. I think there are certain times we will be pushing to the US Supreme Court, right? We're not going to accept a world in which the 10 Commandments are in public schools. We're not going to not challenge that, even if we think we're going to lose. Like, you just kind of have to stand on principle for something. And so that's not our case either. So that FFRF is involved in that case. I don't know what their strategy would be on that. We regularly talk, like the secular litigators are in regular conversation with each other. So I'm talking to Freedom from Religion Foundation and Americans United for Separation of Church and State and American Atheists and CFI, Center for Inquiry. Like, we're all in dialogue with each other about these issues. You know, everyone comes at it from a slightly different angle, I think. But yeah, the discussions are happening about this. And I think certainly if we were to do something that they didn't agree with, they would let us know about it.
Question 8.
That's me. I've just wondered, you've mentioned that you're doing individual rulings, individual state rulings.
Mm-hmm.
How does that affect, you know, the U.S.? Is something in Montana, is that going to be, you know, that would be acceptable in Oregon?
No. So,
you know, one of the benefits of federal litigation is that you win, and then it impacts, if you win at the US Supreme Court, it impacts everyone. So now, if we win a church-state separation case in Montana in the Montana State Supreme Court under Montana state law, it will not affect someone in Idaho. And that is definitely one of the disadvantages of not being able to get to the US Supreme Court successfully. Yeah. And that's kind of been, you know, and that's kind of what a lot of these groups are doing too, not just in the church-state separation arena. I mean, what I described in church-state separation and the kind of bleakness of the case law for our side, you could extrapolate that to almost any other issue you care about. We're just not going to do that. So like, they're all looking at those issues as well. So the reproductive justice people, they're doing state by state by state. You know, when we were doing assisted dying work, we were going state by state by state because they decided that there was no constitutional right to, you know, assisted dying decades and decades ago. And so when you go state by state by state, it's more time consuming, but you also get to kind of litigate under some more interesting laws. Like, there are a lot of interesting laws around this country that give us some unique opportunities, especially as humanists, with some of the precedent about humanists having the same rights as religious groups. So, pardon?
Precedent?
Can cite what as
The
precedent?
state, another state draws this conclusion?
You can cite it as precedent. It's
Binding on other courts. So a federal judicial decision, if you're at the U.S. Supreme Court, it affects all of us. If you're at an appellate circuit court, it affects the people within that circuit. But certainly Idaho will listen to something that they said in Montana, but it'll never be binding on them. It could be influential though.
Question 9.
The Christian nationalists believe in myth, their mythology. God is on their side, God is good. We know that we have the truth. How do you, in law, I know in your cases, it's one way to behave, but how do you recommend humanists behave when faced with just in conversation by someone that says, oh no, we're a Christian nation. We should be all be Christians. I got my last name is Christian. How do you think?
I can tell you what I do. I mean,
I know what I definitely don't know what the right way to approach that question is. I just try to be kind and show empathy and explain my worldview, and that's the best I can do.
Two or three sentences. What do you say?
what do
When
I?
I say no, but no, the United States is a Christian nation. We're a Christian nation. I think you don't understand.
Right. Yeah. Well, I would
definitely push back. I mean, I don't think there's proof of that. I don't know. I don't know that I've been confronted with that specifically. Someone's telling me disprove that America's a Christian nation. I mean, we do actually quite regularly. I mean, I could talk to you about case law and like historical stuff that disprove that. There's a lot of books about it that you could read. So I don't know if I have like a pithy thing that I say.
And arguing is worthless.
Well, you can talk if you want to talk on the terms of that they're comfortable with.
Yes.
You can talk about how the founding fathers were
deists.
Yeah.
Right. I mean, they were not. They were. I mean, there's just a certain extent to it that they were kind of Christian, but Jefferson and Benjamin Franklin and Thomas Paine, like their writings from the time really reflect big questions about their belief in like the Christian orthodoxy of the time, and kind of that's there really is no better evidence than our First Amendment, I think, which specifically establishes a separation of church and state, and there's no mention of God in the Constitution other than the only thing that it specifically says about one of the only things that it says about religion in our Constitution is that you can't have a religious oath to be in office, right? I mean, the document itself kind of supports your position, our position. So.
First Amendment would disagree.
Yeah, I mean, and as with the founding fathers.
Right. Okay. Because you need a sentence. You just need this conversation.
I know.
Number 11, though.
All right, question 10.
No, 11.
Oh, 11, sorry. 10.
Number 11, you just admitted that you can't prove that we're not a Christian. What do you do when the Supreme Court says, we're not establishing a state religion? The people established it. We're just maintaining it.
I don't know. What do we do?
Well, I'll read the text and I'll think of a better counter argument from a legal perspective. I figured that out at the time when that happens. I don't think it's going to look like that specifically. I don't think you're going to get, like, we already have U.S. Supreme Court precedent that kind of talks about the role of Christianity at the founding of the country and how we need to have space for that. They're not going to write out completely these general principles are just going to make it so hard to access that we're going to have to find different approaches. People don't want that, though. You know, the U.S. Supreme Court has to deal with like popular sentiment. It's you know, they operate kind of dialectically, right? They are responsive. They're only going as far as they can from a social perspective, right? And as far as we allow them to go, there's always going to be a counter response to what they're doing, and they've gone really far already, and we kind of need to show them that they can't go any further from like a movement and a social perspective. And that's actually what the best thing that we can do to push back against that is to build our social movement and not think so much about the technical legal arguments, because they're kind of irrelevant right now. They're relevant, we make them, but how power is actually operating is not through logic at the US Supreme Court.
All right, question 12.
No,
11, okay.
The Iroquois Nation, indigenous people, had great influence on our effort at representative democracy. Is that going to be questioned by the Supreme Court if we become this white Christian perspective that they don't count?
Oh, I don't know. I'd like to read.
That sounds great.
Next question 12.
It's my understanding, though it may be incorrect, that there are laws on the books in some states that prevent atheists from holding office. And is American Humanist doing anything about those laws?
We're not. Let me tell you.
But you're right. You're right that there are laws that say you have to. So if we want to get really technical about it, there's a 1962 case called Torcaso v. Watkins. And what they said is that those laws are unconstitutional. And so to 62, maybe 63, but so it's kind of like the way that it works in America is you could have unenforceable laws on the books. The court does not have the legal right to to remove a law from the book. They can just say that the law is unenforceable. And so that's what we have. Now, if someone tries to enforce that law, as they have in the past, you know, I was just talking to a gentleman in South Carolina who was at the center of a lawsuit like that in the 80s, right? We will definitely be all over it. But I don't think that that's the main barrier, but maybe they'll try to bring that back, you know, and we'll be ready if they are. But I think that's even that, I think overturning that might still be beyond the pale of the current court right now. I think that, oh, you never know.
Great. Question 13.
I have one suggestion for what you might say to someone, and then I have another kind of question. But I think I could say something like, I could honor the fact that you believe what yada yada yada, the Christian philosophy, and can you find it in yourself to honor in me an opposing position and maintain the friendship? Maybe that's kind of the way you're thinking. I don't know.
That's really good.
That's good. That's good. But my question has to do with how much power does an amicus brief actually have? And the more you have, the better, I would think.
It's kind of amicus briefs matter depending on who you are and who the judges are. You know, if we submit an amicus brief to the US Supreme Court, I think that matters to Sotomayor. I think to the liberal judges, they'll be happy to read our arguments. How much it moves like the Samuel Alitos of the world, I'm not sure. We still do it because it's important to push ideas forward and get our positions out. So we still do it. There are certain amicus briefs I've seen that are very influential because if you have new information that the court hasn't considered, when the Christian nationalist groups file their amicus briefs to the US Supreme Court, they're extremely influential because they're telling the judges how they want them to rule. So that matters a lot. Kind of like to reiterate the theme, it's really about power and who holds it. And amicus brief is often a way to show people how a segment of people view something, and such that it might influence the judges. So if the Greater Humanists of Portland file an amicus brief to the Oregon State Supreme Court, it would matter, right? They're going to be receptive to us. They care what we think, I would imagine, because they're more tolerant and more aligned to our worldview, I would say. It won't matter as much if the Greater Humanists of Portland are trying to get the U.S. Supreme Court to do something on LGBTQ rights.
We still submit them. We still submit these
briefs in these big cases. How much they matter, I think, is an open question. I think there's a lot of utility to doing it. And it's also a good exercise to, what we often do is we use them to find other groups that support us and work with us. So, and kind of build partnerships with them. So there's a social component to, and a movement building component to these briefs that are really key behind the scenes too. But I've written many amicus briefs in my life. I've never had one cited by a judge before, but that does happen. Yeah, I think we just filed one in Texas that I think will actually matter.
Great. Is there any more questions? Thank you so much.
Great. Thanks, everyone.